Laura DeCaro. I happen to be one of the initial members of this organization, and I'm currently sitting as the president of the advisory board with Shabnam and Amanda, actually, which is such a fun thing to have happen. And now I get to introduce Shabnam, which is actually an extreme honor. She is the godmother of all cannabis bar associations. She is this is her brainchild, the NCBA. She is also a dear friend, a trusted colleague, and a confidant and partner in crime. Las Vegas, after all. Shabnam has been practicing law for almost 20 years now. And I swear she looks like she probably passed the bar sometime at the age of 10. She is a recognized expert in cannabis intellectual property law. And she's been spending most of her career in private practice, but she recently joined Nuka Enterprises, LLC, which is a Colorado-based manufacturer. Some of you may know as the owner of 1906 Brands, which is a fantastic organization, fantastic brand, has a lot of positive community activity. Very well respected in the cannabis community. But best of all, NCBA was, as I said, her brainchild, and she convinced us to help her launch it in 2014 or 15. She currently does sit on the advisory board with us, and having the team of the three of us back together again, I couldn't be happier. So without further ado, I will let Shabnam introduce her esteemed panelists and just thank her for the opportunity to have not only this platform, but this community of other attorneys. We really owe it all to her. And she did it all with a family and an amazing legal career. That I passed the torch.
Wow, I hardly even know what to say. I feel like we should just all go home now. Thank you. That's it. This session is over. Thanks, Laura. As Laura mentioned, her and I and my good friend and our joint colleague, Amanda Conley and Mary Shapiro and a few others founded this organization. And I will tell you what, it's now that I've just recently made the move to in-house, it's definitely like, boy, am I ever glad I have this group to lean in on, which brings me to this panel and my co-panelists. So we're going to discuss all things sort of in-house, focusing on managing risk, managing litigation. Who I have here with me is first on my video right is Craig Abruzzo. Craig is the Chief Legal Officer, GC of Kiva Brands. I've known Craig for a few years, met him through their outside counsel as well. Craig has a really interesting history, and we're going to get into everybody's background here, but has sort of jumped around, helped grow several other companies before he came to Kiva, and that's after having spent some time in private practice as well. Craig actually has helped grow Kiva as well into 11 different markets, I believe, 11 different states. And he's been actually in the forming of this panel, and I hope going forward a real sounding board for me. But I'm telling these gentlemen right now that they're going to end up becoming my mentors, whether they like it or not. The other panelist is Eduardo Provencio. Eduardo is General Counsel, Corporate Secretary, Director of Business Development for Bellrock Brands. Eduardo, too, sort of, it sounds like started at, or as we discussed, both the companies that kind of kept growing. That's Mary's Medicinals and Bellrock Brands, and is now Chief Legal at Bellrock Brands, which is public, and oversees several brands. We're going to get into that as well. So this is exciting for me to lead this panel. In some ways, I feel like I'm really uniquely qualified to do it. In some ways, I feel like I'm not qualified at all to lead this conversation, but I'm excited to be here. And I want to just kind of get right into it. We're going to organize our conversation in sort of three parts. And the first part, I wanted to just focus on a little bit about this job, what it's like, where we all came from, how we've ended up where we are. I, like everybody else, may have some dogs interrupting me at some point. So in addition to answering these questions, I'd like you both also to talk a little bit about your backgrounds when we start. But I want to know, so first of all, Craig, if we can start with you, can you talk to us a little bit first about your history and about transitioning, because I think we share something in common about transitioning from private practice into the in-house counsel role and then growing with several other companies before you got to Kiva, and how your background worked, jumping from one coast to the other. Give us a quick overview, please.
Sure. Well, I would say I'm a cautionary tale. Going in-house kind of early. I was working at a corporate litigation practice, big law in New York, and I was miserable, just miserable. And I had a friend who was working in an internet company. I was only practicing for 3 years, and he was like, "Hey, we need an in-house counsel to help us with our biz dev department. We needed to, like, review contracts, draft contracts, and sort of be a business partner to our biz dev team." And I was like, "I don't know anything about the internet." And he's like, "It's 1999, dude. Like, nobody knows anything about this place. Just come over." And so I took the jump then. I was only practicing for 3 years. And I would not recommend that to most attorneys. Like, the learning curve there in-house and I was the only in-house counsel at a company that had just gone public, that had then in a couple of months went through a round of layoffs and then went private. And I was the only, and somehow I became like in charge of HR, in charge of like corporate development, like everything was like me. And I was literally a 5th-year associate, like not smart. But anyway, it all worked out great. I went from internet media to in 2012, I went to Birchbox and started working at Birchbox. That was my first introduction to kind of a regulated industry, cosmetics, and CPG. And so, unlike most people who try to leave regulated industries, I went from one regulated industry to a more regulated industry, which was food at Thrive Market, and sort of joined early there and left when that was about 600 employees, doing about 400 million in revenue, and then came to cannabis. We had a common investor. That's how I sort of got introduced to Kiva. Met with Kiva, Scott and Christy, really sort of fell in love with them and thought this was the thing to do. And the difference between being in-house and being outside counsel is really about being a true business partner on every level. Because so I just hired our corporate counsel, who started last Monday, and he worked at a firm, and I had him meeting with a procurement team, and so he is now meeting with every business team to understand their legal challenges, in a way that like he never got insight into. He really saw how the sausage is made. Where even as outside counsel, usually as litigation, you only see like when the shit really hit the fan, but you don't see how the shit starts to stink from when it doesn't stink, right? And so we get to see the whole evolution of it all, and sometimes you see it coming, and sometimes you don't.
Mm-hmm. It's interesting you say that, because in the beginning, when we launched today's event, Ian had asked me, what is like the most different thing that I'm observing being in-house. And it's very similar to that. It's that as outside counsel, I didn't really see how the early days of the shit being made. And now I realize, like, wow, this is what's going on, particularly in supply chain. And we'll hopefully talk about that a little bit. But like, right, it's what's happening on the company end and in the trenches is very different than what's happening, at least for me, from the outside in the regulatory end, and in the expectation of regulators and lawmakers versus what a business person needs to do to get the supplies they need to put a product together and then get it out to market. So yeah, I think like meeting with the business teams has been such a big part of the education. Eduardo, can you tell us a little bit? So you were actually in a really unique area of private practice and then jumped to cannabis. Can you share with us a little bit about that?
Yeah, so I started at law is actually my second career. I was in intercollegiate athletics for about a dozen years before I went to law school. I was coaching college tennis teams around the country, and decided driving
totally
15
look like a
passenger
tennis
vans with
player.
18-year-olds was, if I'm still doing that when I'm 40, I may have kind of taken a detour here that I didn't want to take. But regardless, I went to law school with the idea that I wanted to go represent Indian tribes and serve Indian tribal initiatives. And I was fortunate enough, I actually went to law school in New Mexico, which had a great Indian law program, and figured out a way to get up to Colorado, which is where I lived before for one of my coaching jobs, and loved it. and was doing that. And honestly, I thought it was going to be, put in your years, make partner and just kind of keep on rolling. There was nothing entrepreneurial about what I wanted to do. And I was doing that for a long time. I was actually representing tribes. I was doing some general counsel work, but it was a lot of internal corporate governance work. My area of specialty was Indian Reserve water rights, which is actually an issue right now because the Supreme Court actually heard an argument today on Indian Reserve water rights that piqued my interest again. But regardless, it was nothing applicable to cannabis. This was in 2016, and I had friends who had started a cannabis company here, and they were outsourcing all their legal needs, and they were paying a complete arm and a leg because at the time there weren't a whole lot of people doing it. It was really hard to find people willing to take on your work. And we sat down, we realized that we could probably save them a little bit of money, but going from Indian law is very highly federally regulated. Obviously it just the weird Indian law dynamic. I knew really nothing about cannabis, but I was hoping that the federal regulatory environment would at least make it a little bit easier for me to navigate through the cannabis regs in Colorado as they were emerging. So I came in house and literally, I tried to fake it as long as I could until I could learn as much as possible. Right. The good news was I think everyone was really faking it at the time. I think everyone was trying to sort out exactly what was going on. Obviously, I'm sure there are people on this, legal minds on this call that were probably the trailblazers there. But so I really had no aspiration to get into cannabis until I got into cannabis, and I love it. It's something that I don't regret at all. I enjoy the entrepreneurial side of it, and working with a company, a small startup, that it's kind of blossomed into something else. You're working for 3 or 4 different companies without ever having to change offices. So that's been it's been really enjoyable. But I'm not sure if anyone's actually equipped. Maybe this generation's lawyers are actually equipped to leave law school and enter into the cannabis space. But I think everyone has stories like ours, right? And they just think they're disciplined. It took a bit of a leap of faith at the time. This is the one story. I remember talking with the CEO and CFO in 2016 saying, if I commit to you guys, you have to commit back to me because I'm damaged goods at this point. I was working for a law firm, and at the time it wasn't very acceptable if you got laid off and you had to go back into private practice, are you, is that the scarlet letter, right? So it all worked out great. And I think that tide has changed. But we've come a long way because of that.
Yeah, it's so interesting you say that. I mean, I remember when the companies that we represented or partners of those companies didn't have in-house counsel. It was really rare. And then it was interesting who was being brought in as in-house counsel. And sometimes it was really junior lawyers, actually, Craig, like you're saying, is at your start. Part of it was because I think some of the business folks in the cannabis sector didn't really know the value of in-house counsel, but maybe they thought they needed a lawyer. So they sort of brought in a more junior lawyer, an experienced lawyer. But now I see more of it. And it's like you're saying, Eduardo, I think the tides have changed, and it's really a privilege to be able to be in-house counsel in a cannabis company right now and help shape the industry and shape the sector in a way that's different than being outside. Eduardo, I noticed that Bell Rock Brands has a lot of really innovative brands and products underneath it. How are you balancing that? And this is the case for me, is sort of balancing this company's drive and innovation, which I think is very unique in this sector. It's like early tech days, like the regulations aren't all there, or sometimes they haven't caught up. So on the one hand, there's this drive for innovation in a huge, vast area that's developing. And on the other hand, there's the lawyer who's like, oh my God, risk, litigation, exposure, potentially lack of insurance. How do you balance that?
Yeah, I mean, it's hard. I mean, luckily that in my role, I work pretty closely with the CEO and president of our company. So any sort of innovation discussions runs obviously through him, but by default, it runs through me as well. Our CEO came from, big CPG, Frito-Lay, Grupo Bimbo. So he understands kind of how that CPG world works. But it's still, we still find times where, a great example is, a lot of products out there right now, for instance, that are promoting, certain ingredients, right? Melatonin or some other sort of ingredient that may be allowable in states, and may not, right? So it becomes a really interesting research project where if someone comes, you say, hey, I'd love to make a sleep product, right? Okay, well, what does that mean? Is it going to be CBN, or is it, well, we'd like to add something else to be a real differentiator? Okay, well, we need to dive into this, right? And a lot of times the regulations are silent to it because, Shawna, to your point, we're kind of ahead of the regulatory construction as we develop. So it's hard. I mean, I think there are a lot of, you have to ask a million questions to punch holes in innovation before you're willing to bring it to market. It may be a great idea, and we see this all the time. It may be a great idea. There may be an easy way to do it, but in cannabis, it's never easy, right? It's always the most difficult, probably Rube Goldberg, machine type of way to have to get something done in order to get it done. So we spent a lot of time discussing kind of the legal traps, the regulatory traps, and then once we get through that, then the innovation proceeds. So, and we've seen it just from personal experience, we've seen it. Obviously, we just put out a reason why I use the sleep the sleep ideas. We just put out a product that spent a lot of time talking about what the product name is going to be in order to steer clear of medical claims, what the ingredients can be based upon what state it's going to be manufactured in, what the label is going to have to say, how it gets marketed. We had similar issues with our transdermal patches on the Mayor's medicinal side, right? You start talking about transdermal technology, and that teeters pretty close to what would constitute a medical device.
Right.
So how do we deal with those traps? So we've gone through this process enough where we haven't gotten it perfect, but we've at least advanced the ball on it. So we've been fortunate, but knocking on wood, we're just waiting for that next new innovation to stay ahead of everybody else. And who knows what you're gonna run into.
Yeah, it's kind of a scary but exciting area to be in. Do each of you have separate compliance departments from your legal department for internal compliance? I don't mean like corporate hygiene, ESG type compliance, but just product compliance. Does that run outside of legal or within the legal department?
It's under the legal, it's in the legal team, but it's its own team. It all reports up to the chief legal and me, but it's a separate team. I don't have lawyers on that team. That team are compliance professionals.
Oh, interesting. No lawyers on your compliance team.
Yeah, we actually moved after the RTO, we moved our compliance team out from under ops and had them report to legal to create, obviously, a nice, I guess, necessary tension is what we call it.
Right.
But again, there are no attorneys on that compliance team. They're all compliance professionals. Right.
Craig, Kiva's actually been, a real, I think, market leader in California long before we had regulations drawn up. I always thought of Kiva as kind of a model for how you package a product, for how you develop a brand, for how you label a product, even without regulations. How did you feel, and how did the company navigate the onset of regulations when you were kind of already doing it so well?
It's interesting. It was before I joined, but the history is that they were sort of like already doing it, and for the most part, the regs sort of were hand in glove with what we were doing. Like the whole idea of testing, Scott and Christie were doing the testing before testing was mandated, and their whole premise was like consistent dosage. People should know what's in their product, and they should get consistent dosing. So they started doing the testing when they didn't need to do it. So when testing came about, it was not a big a deal. Where, I think Eduardo it's the same situation. Like now it's really about forward look, like what do we want to do in the innovation part. We've been lucky that we've hired a lot of like big food, like dropouts, people who worked in like big food who want to do something more interesting, that understand FDA regs and how to make claims. Like we've also hired people from the supplement world who understand like what you can and cannot do outside of like cannabis claims and like claims of like CBN, but like the idea of like what a disease claim is, or what a structure function claim is. And we train marketing regularly about how to think about those things. And if we didn't do that, then it would always be clean up a mess. So we try and like get ahead of it and explain to them. I mean, I see them sleeping during these things, but like generally we try and like explain to them like what a structure function claim is, what the difference is between like a disease claim and how you could walk the line and still feel confident that we're on the right side of the line. Especially, you know, as Eduardo was saying with sleep things and like, you know, CBD with like full body, this or that, and what do you say, what you can say, what you can't say. We've been fortunate that we've hired folks that sort of get it already, because we've had outside. I've used in my previous life, we had, you know, big private label practice. We had an outside firm that did a lot of our label help on the structure function stuff for the supplements. They won't work with us anymore. Like they won't, because we're a cannabis company. So I'm not going to name the big firm, but it's a big firm who is like very prominent in the food FDA space, in the supplement space. And so we had to bring a lot of that in-house. And
I was
like,
actually going to ask that. Are you doing that in-house? I mean, these are so many different disciplines in the world of law and compliance. Is it a lot you're learning, your teams are learning, you're bringing in outside counsel?
we've sort of built that muscle internally. We've hired people that have that basic muscle, and we've sort of built, like worked on it in the cannabis realm. And to the extent that I could obliquely use outside counsel that won't work with cannabis firms, we don't mention that it's cannabis. We just ask the structure function claim in a vacuum about a specific ingredient that's not a cannabis ingredient, and that works out well sometimes. But yeah, we try to like figure out the best path, because it is, and as everyone in this call knows, like you have to improvise, adapt, and overcome, because this is, we're building the ship as we're sailing it.
Yeah, absolutely. And that's where really like the risk mitigation comes in, when you're making those decisions about how much risk you're willing to take on. So you're in 11 states. How do you deal with the multiple regulatory systems of the different states? And Eduardo, you mentioned this too. Is this all leaning in on outside counsel in different states, or even in that department, you're sort of handling it in-house?
Yeah, so I mean, just a couple thoughts to what Craig was saying to jog my memory. One of the things that Craig's company Kiva has done, and they've been kind of on the forefront of this, is being really, really responsible stakeholders, right? So when there's a series of, you know, for a while, there's a lot of tumult in California, for instance, because you had 3 different regulatory bodies trying to regulate one industry, and the left hand doesn't know what the right hand is doing. It could have been very, very easy to manipulate that for I'd say a market advantage that may be short-lived, and you know it's going to get regulated out. But what Kiva's done, and you know, not to, I'm patting your back, Craig. I'm not sure if you were there still or at the time, but they've just done it right. They've been responsible market participants. And I think that carries a lot of clout. I mean, I think the state will likely comes to you, and then, you know, seeks feedback from your team, because you guys have been true stakeholders with, you know, consumers, safety in mind. So, and you know, and as far as the kind of the issues with medical claims and things like that, it's funny you talk about bringing people in house that are good with that. Our biggest challenge is that Mary's has always been not so much our team internally, but it's the folks, the private equity folks before we were public, that really wanted to push the envelope, saying, hey, we should really go after this. And that's a tough discussion to have with them, saying, well, you can't, because you're probably going to end up getting sued for something, Prop 65 claims, or if it's, you know, some sort of false medical claim, whatever it is. But sorry, I digress. As far as your question goes, Shaba, yeah, it's we structure all of it. So we're in 11 states in Canada as well, of which there are 3 states we have affiliate partners, you know, people within our organization that own the licenses. So we kind of refer to them as quote unquote our licenses, just in more of a colloquial sense, even though they're not the company's licenses. But we structured all of our relationships where we try to control the products to the greatest extent that we can within the 4 walls of the building. And then we realize once it hits the door and exits, it's the license holder and that license number that's associated with that product that really kind of has the outwardly projected liability, right? And that may vary from state to state, right? I mean, I think every state defines plant touching activity a little bit differently, or commercial cannabis activity. So we pay pretty close attention to what that means from state to state. And then we structure our deals that way. And then, all of our deals, we enter stage through essentially licensing agreements, right? So you're licensing IP. You're buying all the non-cannabis raw materials with all the trademarks and everything from a supplier that happens to be part of our corporate, umbrella as well. And it's an easy way to extract, revenue out of the relationship. But when all is said and done, we're really shifting liability to the partner that holds the license, because that person has more to lose than anybody. That person has the opportunity to potentially lose their license if they're not operating on the up and up. So we've done a pretty good job of structuring our deals that way.
Are they accepting liability even when the formulation and the SOPs are coming from you, everything but the cannabis ingredients, and they're still accepting liability for that?
That's the one carve out. That's a very good call. Yeah, and that's exactly right. So as far as packaging goes, as far as as far as marketing material goes, we have some sort of consultation relationship saying, hey, we think based upon the regulation of your state, we think the packaging needs to look like this with this THC symbol. We think the marketing material can look like this. But when all is said and done, it's you control that. We can't assert control over your license. So you are assuming all liability for that, unless there is an issue with a flaw in SOP or formulation.
Interesting. Who's the ultimate decision maker within your organizations about, let's say, an informal recall if you get reports of an adverse reaction, or for whatever reason something goes wrong, maybe with the packaging? A formal recall doesn't happen, but now there's a moment of truth. You have to decide whether or not to pull the product from the shelves. And let's say business teams don't want to. You perceive a lot of risk by leaving the product on the shelf. Who's the ultimate decision maker there, and how do you resolve that sort of tension?
Is it a product recall or a product withdrawal? So product withdrawal is just
right, not a formal recall. Like you sort of unofficially, you have the opportunity to pull.
Consumers, are we making a more consumer-wide callback, or are we just taking it off the shelves?
Just taking it off the shelves, let's say. But actually, that's a really good question. Let's make it two-part.
If there was a like adverse action, I don't think that we, like for me, the product, the withdrawal market withdrawal would be just if there's a quality issue. If there was a question of health or safety, we would go recall. I don't think, I think that I'm of the school of cut deep, cut once, do it and be transparent, and you will build brand equity. You actually, like in my previous life at Thrive Market, we had a peanut butter withdrawal for listeria, and it was a co-manufacturer who had in another brand that they were producing for, and we had to do a full. So the question was, well, none of our products tested for it, but I convinced the board. I was like, look, like you can't test for listeria. You can't test your way out of an illness, right? So like, I know it's going to cost more money, but if you're transparent with the consumer and there's a health and safety issue, they will respect that, and that will come back threefold, I think, as far as like reputation goes. So the ultimate decider, knock wood, we haven't had to make that decision. But I think it would be the board really, ultimately.
Yeah, listen, I think that's right. I mean, I think this goes to the kind of the responsibility we have as general counsel to advise and consult on, possible legal outcomes. I think one of the interesting nuances that we probably run into in our roles is that we also, I think we can talk a little bit about potential PR outcomes as well, on top of the kind of the legal issues, right? One of the examples I use, I remember when CBN was emerging on the hemp-derived side pre-farm bill, and there was some debate as to whether or not it was considered psychotropic, and there was a lot of debate as to, well, are you willing to take the leap and put out hemp-derived CBN products? And the question was, well, you could probably make an argument that it's fine. We're potentially exposed to a market withdrawal, but there's also just a PR nightmare of maybe a 10-year-old getting into a bag of 200 milligrams of CBN and having a big issue with it. The parents freak out, and then it comes back in your company. So it's an interesting balancing act that I think you can sometimes on the legal side you can support your legal argument with an appeal to sensibility.
I think that's exactly right. And that's a lot of, I mean, the job seems to entail, as far as I can tell, in 2.5 months, a little bit of everything, both just in terms of the day-to-day, some days it's not even lawyering, it's something completely different, but definitely has this broad scope that you can actually make arguments from a bunch of different directions, because now you have a seat at this table with these business units and business partners. But I think that's actually also part of what makes the job really difficult. As outside counsel, I felt very tactical. I often had a specific job to do. I would do it and then it was over. And in-house is just so much more strategic, so much more bigger picture thinking. How involved are you with your business groups when you're trying to make a strategic decision, whether it's about engaging in litigation, avoiding litigation by accepting settlement. In particular, when you have a business concern such as a raise going on, are you just deciding it with yourself and your legal team, or are you really engaging the business teams to put pieces together to make a decision?
Like, that for
Either of you, both of you.
I'm talking to these guys all the time, especially if we know there's like conflict somewhere. Like, I know before we're close to litigation that we're having a problem with a partner, or we're having a problem with a product, or whatever it is. Like, there's like, as you sit at the table, so far in advance before it gets to the point of litigation, that you sort of see it coming inside of slow motion. It's weird. So by that time, you're definitely like you're embedded with them to discuss the problem. When it gets to the point of making litigation decisions, you feel like you're just part of the business team with just a little bit extra knowledge of like this other function, and you're sort of bringing that to the table. And sort of steering them back to, especially when emotions run high, and you try and steer them back to, let's think about this for a second, because it's not worth the toss. It's not enough money to like start a war or whatever it is. But yeah, I mean, I think that you're never doing anything in a vacuum, because the issues don't come in a vacuum. It's not like you get a letter that out of nowhere, like, that letter is going to come usually. If it's a commercial issue, if it's a commercial,
Yeah.
I think that's right, Craig. I mean, I think there's an element too of, we work, despite how much the actual industry has grown, we still work in a pretty small industry. So I think there's a real advantage, real benefit to try to navigate a lot of these potentially adversarial moments through some sort of resolution, because everybody else in the space, and you never know what impact that's going to have on you. There will be times where litigation is going to be necessary, but I think you want your stakeholders that surround you to realize that, wow, if it's gotten to this point, it must be serious, because they're generally they're not very litigious people, and they're fairly responsible. As far as the issue about, if you're trying to get PE money in or whatever it is, it's just so hard. I mean, that information is there. It's just it's the question of when it's going to be discovered. Right. That's likely going to have to be a rep and warranty anyway, in any sort of agreement to infuse capital in your organization, that there's no threat or pending litigation. So you might as well be candid about it. And it doesn't, I think hiding the ball doesn't get you anywhere. And to be honest, I think that candor probably goes a long way with whoever's investing in your organization, and say, hey, I think an honest discussion there could also demonstrate that you are responsible folks within the organization, or actually within the industry, and it's worth putting your money here relative, to another organization within cannabis. So.
Right.
Yeah, and I think to build on that, it's interesting. Like, most PE and VC firms and like, this is from my former life, I worked a lot of PE and not as many these days because there's not much money out there. But I very rare, unless it was a massive litigation that was like tank the company litigation, I've never seen a VC or a PE company make a decision based on a litigation.
Right.
They're betting on a much bigger value.
Yeah.
And so it's a couple $100,000, even 2 million, $3 million litigation. Like that is not going to stop. That is not going to stop an investment. If someone's looking at, 10, 700, $800 million valuation or whatever, even like a $50 million valuation, it's not going to, a $2 million litigation is not going to tank a $50 million valuation.
Right.
Because odds are it'll be settled for a lesser amount,
Mhm.
unless it's a regulatory action that's like that the government is coming after you, or it's like an IP that's like at the very core of the business. Other than
Mhm.
that, I
Right.
really don't see like it really affecting a raise.
Right. Speaking of candor and disclosures, Eduardo, can you tell us, maybe the top 3 things that make being general counsel at a public cannabis company harder than when you were general counsel at a private cannabis company?
Yeah, I mean, the
Limit the
public
list to
company.
3. Just kidding.
Oh yeah, let me write it. I mean, it's amazing. It's amazing the thought process that has to go into every single kind of legal action the company takes in terms of, is this material non-public information? Is this, does this require some sort of release to the markets? What impact does this require? Does this trigger some sort of filing form with the CSE? Those things, in the past, when you're private, press releases were to essentially, pat yourself on the back and let people know that you're doing good things.
Yeah.
In cannabis these days, to Craig's point, there's a little rough market right now. A lot of your press releases are just like, hey, things aren't going so great, but we're getting there. It's one of those, unfortunately. And we're seeing that right now. And I'd say that kiddingly, but we see it. A lot of people are obviously, you've got required financial disclosures. You're seeing changes in leadership with organizations for whatever reason. It seems like a lot of what you're seeing right now is, hey, we're not doing as poorly as the next guy, so we're doing well, right? So you're dealing with that. You're dealing with that analysis all the time. You're dealing with that calculus all the time. We've been fortunate that we actually have good outside counsel. Because we're traded in Canada, we do use Canadian Public Securities Counsel, and they're incredibly helpful. They've been really good stewards to us, and they keep us kind of on track. Again, but it's the battle of, how much do we have to disclose and when do we have to disclose it?
Right.
For X, Y, and Z, for whatever reason you want to do it. Say the regulations are what they are. I don't think you want to mess with the, with the BCSC or the CSE.
Right.
So.
And we're under so much of a microscope too in the cannabis sector. It's almost like a bunch of disclosures are already made for you just by virtue of how quickly the news cycle works and is like way ahead, announcing all manner of risks that may or may not exist. I know that you're part of your role, Eduardo, is business development. I know you mentioned this earlier, Craig. How do you resolve the tension between taking advantage of a business development opportunity, whether it's a new product market or a new partner or just a new market, versus the legal risk it presents? It seems to me that sometimes business development and like mitigating legal risk are at odds a little bit. And it kind of goes back to the idea of pushing the envelope with innovation too. Is there tension there for you, or it's pretty smooth relationship in those two roles? I guess Eduardo, really, they're both your roles.
Yeah, it can be difficult. I mean, a lot of it will depend upon, we do, with our expansion efforts, we're obviously looking at, new states to expand into. And any sort of analysis there is going to be what the regulatory environment's like, what the license structure is, a limited license state, what it looks like there, right? How opposed are states, or how difficult do states make it to enter a state under a licensing agreement? We've seen, that you fall anywhere in the spectrum, right? California was very, very, very difficult when they first put out their initial wave of regulations. They've come around. Actually, Ian Stewart, who is, I know, part of Input here, Ian and I worked on some comments way back when to talk about that. Michigan's the same way. Michigan requires pre-approval of all licensing agreements right now before you can even go to market, and that could take a long time. So there's an element of, and that's a great example, for instance, of people saying, well, let's just do it. What are the chances of them finding out, right? So, well, that's not a great legal analysis, right?
Ask forgiveness, not permission. No.
Yeah, exactly. Yeah, exactly right. So things like that. I mean, I think that's where the tension arises. But if there's a good
Yeah.
assessment at the very beginning, and I'm usually the one out pitching potential partners, so I usually know a lot of that on the front end going in. But then that's usually a pretty candid discussion with our potential partner to say, hey, we do want to do this on the up and up. You know, we're not going to try to hide from the regulators. We want to make sure, again, we're responsible market participants within the state, because maybe at some point we do want to own a license there. So we just don't want to have the reputation of shirking our responsibilities.
Yeah. How do you is it possible to unwind things, like if you get to a company and it's more mature at the time that you enter as in-house counsel, and you find that maybe there's some practices you want to come in and impose a set of rules onto? Is that possible, or what is the best practice in that situation? You come in, you're like, a little bit of housekeeping needs to happen here. Is it about unwinding things? Is it more go forward? What's your best approach to implementing systems in an already existing system?
Craig, you want to take this one?
If you have
Because
to,
you joined a company that was actually pretty mature.
Right.
Yeah, if you could possibly avoid unwinding things, don't. And if you can just do it on a prospective basis, do that. It's really like the only time you would want to unwind things if it was completely unavoidable, right? And like mostly from a business disruption. But I found that if you explain to people why, and especially the executive team and the board, like, if you don't do this, this is what's gonna happen. And I think if it is a mature company, a publicly traded company that Eduardo's like, that's like sort of like it has to happen. And a company with like aspirations to be a larger company or a public company, like the investors need that. Like they can't not, and as much as it sucks and everyone's going to hate you for it, but they'll know that they have to do it anyway, because if they really want to grow the company as a company and not just have like, oh, I'm going to like get it to a certain point and sell it and leave, which, that's not a mature company. You got to do it. Like, and I'm sure like if I brought a CFO in to talk about accounting practices and reforecast and issuing financials from past years, like that, like we got it easy relatively. Like our stuff is like sort of functional, and maybe we have to do a couple of board approvals to like redo some stuff. But like financial folks, the CFOs come in and they got to really restate past years. If they ever want to move forward and get professional money, then that's that. I don't want to have to deliver that message.
Yeah, that's got to be painful. Absolutely. Let's turn to just one. We're actually almost out of time here, but I wanted to ask a couple questions before we end. One is on the issue, and they covered this a little bit in the panel before, of privilege. And I read the links, thank you, that you sent me, Eduardo, and I'm getting them up to speed on that. But when you're in a either an immediate sort of pre-litigation or anticipating litigation situation, or actively in litigation, how do you navigate that internally when you need to have conversations with a lot of different business teams? Sometimes you're wearing your lawyer hat. Sometimes maybe you're not wearing your lawyer hat. How do you balance that? How do you balance that? Quick, tell me, because I need to have internal conversations. Should I write something in particular at the top of my emails, and I mean, even maybe in early product development stages, when you want to start thinking now about stuff you want to be protecting potentially years down the line.
Yeah, I mean, if something's coming down the pipeline and obviously you're aware of it, there's a candid discussion we have right away with any sort of stakeholder within our business that we may need to lean upon to get information, right? And it's we loop in outside counsel right away, because we need a set of eyes, a set of unvarnished eyes looking at the issue. And that helps quite a bit, right? I mean, there's the having outside counsel on for a lot of these communications and these discussions helps create a nice defensible position about what would constitute privilege. the part where it gets sticky is sometimes when you begin, and this is more of a hypothetical than anything, but when as the general counsel for the company, you oftentimes have to steer some of your executive or your leadership or your board or whomever else back to the idea that you are the company's attorney. So if there are discussions about all of a sudden about maybe individual responsibilities, maybe that are outside the official scope, that's where it could potentially get sticky, where you have to be very, very clear to stop everyone from chatting. And again, this is kind of a hypothetical. We've never gone through that, but it's one of those things where you think about it quite a bit, where you do have some discussions saying, hey, just I represent the company, and by that, for me as a publicly traded company, I actually represent the shareholders. I represent the actual corporate form. I've got responsibilities to the securities entity. So let's be very, very clear about what parameters are for our discussions. If you think, and I say that in the context of potentially a D&O type of claim, something like that may go outside the boundaries of maybe your D&O coverages, and maybe your executives are thinking about, do I need, what kind of exposure am I looking at here? So, but yeah, I mean, we've been fortunate, we haven't had to deal a whole lot with that. The few times that there's a specter of potential litigation, we do have a bit of a process there to make sure any sort of communication there is being structured such that we can hopefully assert privilege.
Right. And Craig, how about you? I know Kiva was involved at least in one fairly well-known piece of trademark related litigation during that period of time. Were you cautious about your internal correspondence, or not too worried about it?
No, obviously you have to remind me of that
Every single time, babe. Every single time.
No, we're caught. I mean, I was a litigator.
You have no other litigation. That's the good news. Is there's nothing else. You're right.
Nothing that's material, but
exactly.
We live in California. We have, I don't know anyone who doesn't have some employment action going on at any
Oh God, yeah.
But I think that, I mean, like I have a litigation background, so I'm very cognizant of the process of setting the wheels in motion when litigation starts, and also trying to foresee when like these issues will be an issue in litigation as if anything ever hits the fan. Just to be very careful, like, obviously you can't, like, business advice is not legal advice. And like, also what I do with our senior team, and Edward, I'm sure you do this because you're publicly traded, we do like lunch and learns with our executive team about privilege and what it means. Because like, if you talk to your average layperson, they're like, just include Craig on it and it'll be privilege. Right. Well, that's not how it works. And so like I do lunch and learns to explain privilege and how it works. And I think the more educated the business people are about how it works, the easier it makes your job. And also there's less surprises. So like if something happens down the road and you're like, you kind of discuss this and they know that. But I think like my whole view of legal in-house is like, teach a man to fish, like because we can't scale. Like I have 2 lawyers, I'm going to have a third, but like, it's like we're 700, almost 700 employees across 11. Like, there's no way like we could service them. So at some basic level, you need to teach them a basic understanding of a lot of things, and privilege is one of them. And so we trainings once a quarter on it. It's repetitive and they hate it, but too bad.
I love that, actually. And it comes very intuitively when you think about your marketing teams or your product development teams, and the idea that like every piece of literature that leaves this building is not going to have my eyes on it. I don't want that to happen. They don't want that to happen. So there needs to be this built-in education, and many folks, as I've come to know the company, already have that, and it's already really well developed. But I wouldn't necessarily think to have that kind of internal education on the topic of privilege. And it's a brilliant idea to arm them in the same way I would think to arm a product team about regulatory compliance, navigating between state regulators, FDA, that sort of thing. What, as a final takeaway to our outside counsel audience, what is like the top 1 or 2 things that outside counsel can give you to make your job easier. And I'll tell you mine after you tell me yours.
You
I
go first.
already have one. You want
Uh,
me to
all
go
right.
first?
Yeah,
Yeah.
you go first.
No, you go. Okay. Well, mine is, I'll say this. It's just the counsel part. Like I've already noticed just the counsel. It's the sounding board, having somebody that I can call, and it's really like one or two people and get an immediate, talk this out with me. That has become so important. And I actually really want it and need it with in-house counsel counterparts, but that the willingness of somebody to help me untangle an issue before I even start to put a strategy in place or a team in place has been invaluable. So tell me your two pieces, and then we'll let Jason close us down.
Yeah, I mean, listen, I agree. I mean, I think there's an element of having another set of eyes and ears on something to be able to bounce ideas off of. And that's incredibly important, right? Especially, I did litigation when I first got out of law school and did it for a little while. I was doing, obviously litigation for the tribes, but yeah, I'm rusty, right? I mean, you forget about some of the things. So it's nice to bounce some ideas off of somebody. I mean, a lot of it is you're asking for kind of some legal advice, and then you're folding that into kind of the facts of your business operation, right? Your outside counsel may not intimately understand your business operation like you do, right? But you can apply those legal concepts that may be lingering somewhere in the back of your brain that just need a bit of a shake to get them out. But it creates a really interesting discussion. And then I just think the other part of it too is the legal counselors, they're a great network to everyone else within your organization that you may or may not know. And I use this panel as an example. Like I know Ian Stewart pretty well. I know Jason pretty well. And if not for an introduction, shout out to you, I wouldn't be part of this panel to meet Craig and to meet you. So that's a huge benefit of outside counsel as well.
I'd say short and sweet. Like I like outside counsel who understands I don't want a memo. I don't even want like a one-page memo. I want a quick conversation, 20 minutes on the phone. And I know from a billable hour perspective, it's not ideal, but when the shit does get hairy, that's the person I'm gonna lean on, because like they've been there, like you said, to just like hash out a small issue in a quick and concise manner. And I know that they're not going to like, and this doesn't happen as much anymore, but it used to happen. Like you ask a question and you get like a 5-page memo from a junior associate. Like, I don't want that ever. Like that is not helpful to me. And just knowing the business and like understanding the business and the industry. So, I don't want to like, so.
Oh yeah.
Tax issues, tax litigators. There aren't many cannabis tax litigators. There are a lot of tax counselors, but like litigation is an area where I think it's getting developed, unfortunately. But like to understand the business and the industry saves so much time and energy. To explain cannabis tax world to a non-cannabis tax person is just like a nightmare. Like, so just understand.
Thank you so much. I have learned a lot from you. Just your vibes has taught me something.
Shadman's going to start adopting your vibe.
I am 100%. The look, the whole bit. Thanks a lot, gentlemen. I'm really glad I had the opportunity to meet you through this process, Eduardo, to get to know you better, Craig. And I think we're all done.